SJC-12077, City of Boston v. Boston Police Patrolmen's Association.
Ms. Hodge, good morning.
Morning, Your Honors. May it please the Court, my name is Kay Hodge, and with Jeffrey Bach and with Nicole Taub we represent the City of Boston. In this case, the legislature gave Boston's Police Commissioner the exclusive, non-delegable authority to determine whether a police officer used excessive force and to determine what, if any, discipline would be given for that offense. The Superior Court's decision affirming the arbitration award in which the arbitrator, in this case, the arbitrator usurped the authority of the police commissioner must be reversed. I think it's important to start with the words of the statute.
Let me make sure I understand. So basically, you're saying that the arbitrator is not even entitled to make fact findings as to whether unreasonable force was used. That is solely the prerogative of the police commissioner.
Your Honor, I think that is correct, except that I think that in this case, the arbitrator did make a fact finding. The fact finding was that the police officer used a chokehold in the context of arresting a young man for disturbing the peace while he was drunk and mouthing off.
Nothing in the commissioner's, nothing in the regulations or rules of the department defines chokehold.
I think, Your Honor, that what is interesting is that a chokehold is in fact considered by the department to be lethal force. And
But why don't they say so?
well, I'm not sure that it's necessary that they do so in the sense that I think that the
Departments do. What's wrong with?
some departments do and many do not. And let me just say this, to prohibit a chokehold would mean then that someone would in fact engage in inappropriate conduct in violation of the rule if in fact they came upon someone in a hostage situation. Then I think it might be appropriate to use a chokehold if there were others who might be alerted to the fact that the police were in a particular area. And I just think that not having an absolute prohibition is the sensible thing for a police department, in the same way as it doesn't prohibit every other kind of activity.
So, is it your position that if the arbitrator had made all the findings that he made but didn't use the word chokehold, we wouldn't be here?
I think, Your Honor, our position is this. The statute says that it is the police commissioner of Boston that has the cognizance and control of the disposition and discipline of the department and of the police force of the department.
Why didn't the...
Justice Botsford's question in a different way, if I could, please. What if the arbitrator found that Officer Williams never touched Mr. O'Brien's neck? Would you still be arguing for discharge?
Your Honor, I think that in this particular case, obviously there are any number of factual circumstances. And I think that the language of the statute would clearly encompass complete discretion. You don't have to go there here, because the arbitrator did find, as the court did, and I would just refer to another case which is similar but not on point, because it was under a different statute, but that's Lexington versus Zagajewski. In that particular case, he found, albeit he said it was not serious harassment, he found harassment. And with that finding, the court determined that, in fact, the individual, in that case teacher, was appropriately discharged.
Could I just ask you this? Is it your position, I guess I'm a little confused. You say this is the exclusive authority of the police commissioner under the commissioner's statute. Why then, I mean, if that's the case, once the commissioner discharges somebody for what he determines to be excessive force, why would it go why would it be arbitrable at all? Why didn't you seek to stop the arbitration?
Your Honor, the fact of the matter is that as a matter of expedience and as a matter of appropriate if you will, labor relations, you can allow, the case is going to go to arbitration. The rules of the American Arbitration Association or the rules of arbitration are that it is for the arbitrator to determine the question, if you will, of arbitrability. As somebody who frankly has been to the court, the Superior Court, multiple times in an effort to stop an arbitration, I can tell you it is very often unsuccessful because they say, let's wait to see what the arbitrator does. In this particular case, what you have is you have a situation where you have a statute and you also have the discipline, if you will, the just cause provision, and I would argue to this court that it is for this court to make the decision and to apply the statutory language to this case.
Can I just ask you a question here about, I'm really confused. I thought you said that because the arbitrator found that there was a chokehold, that's the end of the story, that supports the determination. But wait, let me finish. Because I think what you also said was that there are some chokeholds that are okay. Because it's not in the regular, like in the hostage situation. A chokehold might be okay in that situation. Did you
And the
not say
rules-
that?
What I said, Your Honor, is this, that the rules grant, the rules, if
There's
you
no
re-
absolute prohibition in the police regulations against chokeholds, right?
there is no prohibition, and I suggested to Your Honors that that was appropriate, because every
Sometimes
case,
they're okay.
because every case must be on their facts and circumstances.
So if they're okay in some circumstances, how do we know when they're okay and not okay?
Because you look to rely on the professional police commissioner to make that judgment.
So the
And-
police commissioner gets to ultimately decide that fact?
Yes.
In answer to Justice Gantz's
Yes,
first
I'm sorry, to the
question.
extent that I didn't answer that, yes. That is the police commissioner's call. In this case, you don't have to get there
Are there any
because,
limits on the, are there any limits on the commissioner's authority? Suppose he just doesn't like a police officer on an excessive force case.
if there, I mean, frankly, Your Honor, I don't think you need to get there and I think that there is objective information. Here you
Right,
had
I
the finding of a
understand.
chokehold.
Right.
And second of all, and frankly,
But
I
if we-
think
if
it's
we-
for the
if we-
legislature to decide if it is going to be, if somehow that authority is going to be constrained.
What I'm trying to play out is if we adopt your argument and say if there's a commissioner statute, it's absolute, are there any limits on what the commissioner can do?
I think that the fact that there has been historically no case that has come to this court is an example of the fact that the commissioner often, or the police department often, allows some of these cases to go through the system. And I think that's part of the argument of the plaintiff, of the union. And I would argue that because it's jurisdictional, it has never been waived and cannot be waived. And I would further
That's why I'm just so puzzled that you have never tried to stop the arbitration or challenged it on that basis, if you say it's pure jurisdictional? I
would
would think
argue that
every
it is.
excessive force case would have the same argument.
But, Your Honor, in this instance, I mean, I'm unaware of any other excessive force case in the city of Boston. I can only say that in today's particular circumstances, I'm unaware, and perhaps the union may know of others. I don't know of any.
Ms. Hyde,
standing
may
here.
I take you to friendlier territory, public policy, as an answer to the question that's presented in this case? Could you tell us how we get there in this case?
In the area of public policy, as Your Honor knows, and I don't think that the plaintiffs argue that this isn't a well-defined, that not using excessive force is not a well-defined public policy, and that it is involved in this case. The question always is whether or not the reinstatement of a person in this situation would in fact contravene public policy. I would suggest to Your Honors, for the reasons articulated in part by Justice Ireland in his concurring opinion in Lynn versus Thompson, in which he made clear that the use of excessive force would in fact be the kind of circumstance in which it would be appropriate to find a violation of public policy. The police are in the unique circumstance, they are authorized to use force. And the decision and the control of that department depends on the ability of the police commissioner to determine what is or is not appropriate in any given circumstance. The truth is that this court has granted, despite the fact that the collective bargaining agreement may have provided to the contrary, provided specifically, you cannot transfer an officer who is involved with the union. You nevertheless found, and have found, in a number of circumstances, whether it's 2 patrol officers in a car, or the transfer or assignment of work, you have found that it is a part of the non-delegable prerogative of the police commissioner, and that it would not be that you granted the police commissioner that authority.
That's why
Here
it's,
we have the use.
That's why it's so confusing that there's no effort to stop the arbitration. So if a police officer using excessive force, or a police officer lying on the witness stand, raises public policy concerns that no matter what the arbitrator decides, you've got to vacate the arbitrator's decision. If that's the situation, well, what if the arbitrator makes findings that there wasn't excessive force, or there wasn't?
As he did
lying?
here.
He did not.
Well,
I
he
would-
said it wasn't excessive in the
I would suggest to Your Honor that if you read the decision of the arbitrator, that it is his judgment and opinion that in conclusion, it is not a finding of fact. He says there is a chokehold. He says that it was aggressive. But then he goes through and he says, because Boston police officers had guns, had not yet frisked the individual.
But you're getting it, I mean, we can't, as bad as they may be, that's not our job to overturn the findings.
That was an opinion, not a finding. I think there's a
If you label it
distinction.
opinion, it's fair game on judicial
No, I
review?
think it's a decision between, well, what the plaintiff is trying to argue is that you're bound to all of his conclusions, and I would argue in this instance, much as you have in cases involving whether or not you can transfer or assign an officer, that in fact, this is a part of the non-delegable prerogative of the police commissioner.
Is it only Boston, no other police? Because
It is only Boston.
Isn't that peculiar?
You know, Your Honor, there are a lot of things that are peculiar, but the legislature has spoken. It is the clear words of that statute that you're dealing with, and I would suggest to Your Honor that is what this court is bound to apply. Now, I think that you can certainly take into consideration, and under the public policy issue, the question is would the reinstatement, and I think the reinstatement of a person who, in the commissioner's mind, used excessive force, used a chokehold, following, I might suggest, that following on the heels of an individual having died from the use of a chokehold in New York City because he was selling untaxed cigarettes. The problem with the chokehold, and there are few, if any, and Justice Botsford, I can see your look on your face, the fact of the matter is that there are few, if any,
Joining the crowds that think I will never be a poker player?
There are few, if any, cases where the Supreme Court of the United States has opined about a particular method. And the Supreme Court in Lyons versus Los Angeles talked about chokeholds. And it is the unique unpredictability, the fact that it is about putting pressure on the neck area, which may or may not cause strangulation, but may very well cut off blood flow to the brain, which will in fact cut off oxygen. And how unpredictable it is.
On an arbitration, whose facts are we deciding that on? We have to apply the public policy on whose facts. For instance, the arbitrator was sort of squishy, very unclear on whether Officer Williams was lying or not. I think the comment might have been differed from the testimony of his partner. So if we're going to apply this public policy exception, on what facts do we apply it?
I think you apply it on the facts that it was a choke, that he found, in this case, much as in the Zagayeski case, the arbitrator found a chokehold. That is undisputable. He then differed with the police commissioner on whether or not it was or was not excessive force. And we would argue that, in fact, it is the fact of the chokehold that you then apply, and on the untruthfulness, the fact that it was he credited, the arbitrator credited Officer Williams's partner for in defining that it was a chokehold. He described the demonstration that took place with counsel, during the arbitration, where pressure was put on his neck, of the individual victim. And he went on to go through these other issues. And I would just say to your honors this, that the analysis given by the individual arbitrator, that, well, the victim had not, or the suspect had not been frisked, and that the police officers wear a gun. If that is the standard, and remember, this is indisputably disturbing the peace, a drunk and disorderly young man who was mouthing off, then we can use this in any of those situations, and essentially the police commissioner would be essentially powerless. We would argue that the legislature recognized differently, recognized the importance of giving to the professional police commissioner the authority. He is the one responsible to the public. He is the one who will have to stand before the public to justify his decisions and what happened. The arbitrator who determined in this case to reinstate this individual is unknown. It's just a faceless out there. And we would argue that the decision about force and what force is appropriate and who gets to use it should be, certainly under the statute, commissioner statute, the non-delegable prerogative of the police commissioner. And with
Why,
that-
Ms. Hodge, why should we take anything of the fact that this happened in March 15th, 2009? It wasn't until 2 years later, when a lawsuit was pending that ultimately got settled for $1.4 million, that the commissioner undertook to take any action?
No, Your Honor, I don't think that, I think that things take time. As you know, there was a trial board that was in fact convened, which took even longer time.
That was after that, though.
And I would argue, no, that the authority of the police commissioner is determined by the statute, and I would argue that that is what needs to be applied. And if you're going to say that it doesn't apply, that then you run into serious issues with regard to, how you're going to interpret the statute going forward.
So you would say we just ignore the arbitrator's findings?
No, I would argue that you take into account that in this case, that the arbitrator found that police officer Williams used a chokehold, and that is what the police commissioner found was excessive force. And therefore, you do not have to go to some of these other issues. Although I believe the statute allows you to do that to complete discretion, I don't think this is necessarily the case in which you have to decide that.
But we
Or
have
in
to
the alternative, that it's a public policy
We have to
issue.
ignore the findings that he didn't choke or strangle O'Brien.
Well, but we have provided to your honors that the choking and strangling are not necessarily inherent in the theory in a chokehold, because it could be cutting off the blood, which does not affect the airwaves and the, quote, choking.
All right, thank you.
Good morning. May it please the court. Alan Shapiro for the Appalachee Boston Police Patrolmen's Association. The city is attempting to appeal a case that was never tried before the arbitrator or decided by the arbitrator.
You mean the fact? Are you saying that the facts that the city is relying on weren't what was before? Is that what you mean?
Well, what I mean is the case that was tried before the arbitrator was Officer Williams was fired because the police commissioner believed that he choked O'Brien and then he lied about it. It's in the hearing, the whole time spent in the hearing was about whether or not O'Brien was choked. The expert witnesses who testified, the doctor for the police department, Dr. Arnold, the doctor for the union, Dr. Beal, their testimony went to whether or not O'Brien had been choked. The arbitrator found that although Williams put his arm around O'Brien in a way that somebody could look at it and say, yes, that's a chokehold.
Well, he called it a chokehold.
He called it a chokehold because he was differentiating different meanings of the word.
Well, he certainly rejected Williams' testimony that was a bear hug, right?
I wouldn't agree with that. I mean,
We credited Nguyen to say he choked him.
he credited Nguyen to say in Nguyen's description of the hold, he could understand why Nguyen used the phrase chokehold, but he also said,
He credited Nguyen's calling it a chokehold, didn't he?
yes, he did, but he distinguished the word chokehold.
Well, page 41, quote, "It would be accurate to call this a chokehold."
Yes, but he goes on to say that there are different uses of the word chokehold. He specifically talks about there are different meanings of chokehold, that putting somebody in a hold that looks like somebody's being choked, that could be called a chokehold.
Either way, isn't it fair to say it wasn't a bear hug?
I wouldn't agree with that, Your Honor.
Okay,
Okay?
okay.
I mean, there is a picture in the exhibits, which wasn't put into this record, where one could look at it and say it looked like a bear hug.
But then there was something to do with the neck, was there not?
He had his arm on the man's neck.
The picture shows
Apparently, that's not a bear hug.
the grievant, the picture that of the grievant, he had one arm around the back of, as he depicted it for the arbitration hearing.
This is what he was doing, maybe with you, with counsel?
Actually, I was the one taking the pictures. Co-counsel was
The alleged
playing the role of the
O'Brien?
And he had one arm kind of around the back of O'Brien and the other arm around the front of him.
Isn't this what we want the police commissioner to decide, not an arbitrator, as far as how much force and how much we can have someone pressure someone's neck such to lead to petechial hemorrhage in testimony by a fellow officer that there was a chokehold?
The police commissioner's factual findings, the whole case was predicated on the police commissioner's belief that Williams choked O'Brien.
And how did he get that belief?
Because that's what his investigation, according to the police department, that's what it showed. But if nothing else, it seems to me that the union is entitled through the discipline and discharge and arbitration system or its civil service to have a neutral.
So suppose this really was a chokehold in the classic sense, and was causing discomfort, was causing a strangulation kind of response. And the arbitrator nonetheless said, though, in the circumstances, this was a reasonable amount of force.
Well,
where are we then?
Well, first of all, it's a different case.
I understand that, but I'm saying, where are
Okay.
we then? What are the limits of what the arbitrator can do?
Well, I mean, historically, if the chokehold had been an assault, a felonious assault,
Well, I'm not saying that it was a felonious assault. I'm saying that it was just a chokehold in the classic sense, causing strangulation. You can call it a crime if you want to. I'm calling it a chokehold for the purposes.
well, I'm just trying to put this in with the jurisprudence that we have, Your Honor. We have cases that say that if the arbitrator finds that the employee engages in criminal wrongdoing, in felonious conduct, that it doesn't matter that the employee can no longer be a police officer. If the arbitrator says he used more, choked him in that situation, but the officer was in fear of his life in a situation like Attorney Hodge was pointing out, then that's a different situation.
Well, can the arbitrator say, but, okay, so, it was wrong to fire him for doing that? And let's reinstate him?
I mean, if the arbitrator,
At what point does the commissioner's non-delegable authority enter into this?
in discipline and discharge cases, the arbitrator finds the facts. If the facts don't support just cause, then statutorily, we, the legislature, has given to civil service and to arbitrators the ability to decide that there wasn't sufficient just cause. The exceptions...
But what happened here, counsel, as I'm reading this, the arbitrator decided that it was a chokehold, but it didn't matter because it didn't hurt the guy.
It wasn't excessive.
That can't be right, can it? I mean, if it's a chokehold, it's a chokehold. And the guy's lucky that he didn't end up like Eric Garner. So that doesn't take it out of that realm of consideration if it's a chokehold, as he said it was.
Okay. The arbitrator found that the police officer...
No. He found it was a chokehold. We're not going to parse what happened as a result of it, or it was a chokehold, but...
He said it was a chokehold, but not, in the circumstances, not excessive force, I think is what he said.
He said, and I'm looking at page 50 of the transcript, page 41 of the decision. I do not credit, and he's talking about O'Brien's testimony, that the grievant attacked him or choked or strangled him. The city emphasizes Officer Wynn's testimony that the grievant had his arm around O'Brien's neck and he puts chokehold in quotes. But putting someone in a chokehold, in quotes, is not the same thing as choking or strangling him. Chokehold, in quotes, is an imprecise term, and it is not the same thing as choking or strangling.
See, that would be a different problem. You got the one problem, which is the chokehold, but choking and strangling would be something different.
But that's what they fired him for. They did not fire Williams for putting O'Brien in a chokehold. They fired him for choking him. That's why they had the doctors testifying to try to show that he was choked. The police department, as was pointed out, doesn't have a hard and fast rule about whether you can use a chokehold or not use a chokehold. Nobody...
If the police department's, I forget which rule this is, but in terms of when you can use non-lethal force, and if it's said, non-lethal force does not include a chokehold, which we define as whatever.
That'd be a different case.
Okay.
But I mean, in essence...
You wouldn't disagree that the commissioner could, if the commissioner says in that circumstance, based on his investigation, I mean, would the arbitrator be able to say, well, no, I don't really think it was a chokehold? Is that become just a factual question for arbitration?
Yes, I think so. I mean, isn't that what arbitrators decide, is factual
I don't
questions?
know, because then you have the commissioner's statute.
The city fired Williams, it's very clear, because they thought, after a really shoddy investigation, and after they paid O'Brien, as Your Honor pointed out, $1.4 million, somebody whom the arbitrator didn't credit, they fired him on the mistaken belief that he choked O'Brien. They're now trying to turn this case into one where they fired him for putting O'Brien in something that looked like a chokehold. That isn't what he was charged with. That isn't the case that was tried. No witness appeared for the city in the arbitration hearing. No, the commissioner never testified. The highest-ranking person who testified was Superintendent Fong, and he made it quite clear in his testimony that the reason they fired Williams was because they thought he choked O'Brien and then he lied about it.
So-
Not that he put him in a hold that might have looked like a chokehold.
But let's take your view of the arbitrator's findings for a moment. And you've got somebody who puts an individual who's being arrested for disorderly conduct, puts his arm around Mr. O'Brien's neck, and is not honest in the discussions as far as what happened. Is that enough to say that the arbitrator's decision should be vacated as a matter of public policy on these facts?
Well, on your current state of jurisprudence, if the officer perjures himself, that being a felony, if we look at the DeShulo case, for instance, that would say that he couldn't be a police officer anymore. But that's not what this arbitrator found.
Well, significant diversions from his partner's testimony.
The only significant diversion that he mentioned was the way that Officer Wynn used the term chokehold, Officer Williams used the term bear hug. But in the transcript, the internal affairs investigator who testified, McEachran, he said that, and he watched the demonstration that was done at the arbitration hearing, he said that the demonstration was consistent with what Williams had shown him in the 2 interviews that he conducted of Officer Williams. I mean, one of the things that needs to be pointed out here is there has to be some checks and balances on the police commissioner's authority with respect to determining facts. As Justice Botsford pointed out, I mean, this case started in March of 2009. There was a complaint filed very quickly thereafter by O'Brien himself. Williams was never made aware of the complaint. He hired counsel, filed a lawsuit. Williams got served months later. That was the first time Williams was even aware there was anything happening from this. The first time Williams and Wynn were interviewed was more than a year after the incident. And then they were re-interviewed months and months later. I mean, this was not a model of investigatory efficiency. So the current statutory interpretations allow the union, through the collective bargaining agreement, to challenge at least the factual findings that underlay the discipline. And the same with civil service. Civil service, an officer has a right to go to the Civil Service Commission and challenge the findings that were made by the police commissioner.
Shiro, in your experience doing this work, is this are cases in which, in Boston, cases in which involve claim or charges of use of excessive force, do they get arbitrated? Or is this an unusual case that it
I
went
mean,
to
we've had,
arbitration?
the DeShulo case involved excessive force that was decided by this court in 2005, I think. The DeCanto case involved excessive force. That was an appeals court decision more recently. We've had a number of discipline cases that have come up to the appellate courts. And the city, prior to this case, has never made the argument that the arbitrators don't have jurisdiction to make these determinations.
They're making it now, maybe in a different environment, and they're saying that the Boston police commissioner shouldn't have to go through this entire process. That if it looks like excessive force, that for all sorts of reasons, as a matter of public policy, that should be the call of the commissioner. That's their initial position here.
Yes, Your Honor, they're making the argument, frankly. I think they might be trying to seize on the headlines and mentions of Garner and and these other things.
Well,
But
what's
those
wrong
don't.
with that if there's a problem?
There's a problem, absolutely. And if Officer Williams had choked O'Brien, he should have been fired. But he didn't. And there's 1,500 police officers who go out every day to try to do the best that they can and respect the rights of the citizens and the people in the city. And it seems to me they ought to have some rights also to at least get due process in terms of when they're disciplined, that there should be some degree of oversight and ability to at least challenge the facts with respect to what happens.
Did Officer Williams' prior discipline have anything to do with the commissioner's decision in this case?
There's no way of knowing, Your Honor.
Okay, I mean, it wasn't part of the record.
No, it was
Well,
20 years ago.
Did it get mentioned in terms of the lying? Did it come up in that context?
I don't believe so, Your Honor.
Okay, thank you.
Thank you very much.
So there's no progressive discipline.